Minutes for questions. When settling with a company found to have violated federal consumer protection law, the Consumer Bureau has typically required the company to compensate victimized consumers. Astonishingly, Director Kraninger, 3 of the first 5 settlement agreements that you authorized during your tenure as director failed to provide any consumer restitution. Alarmed by this failure, this committee started an investigation and examined the 3 settlements in an effort to understand your rationale for denying consumers compensation in these cases. The committee recently released a majority report detailing its findings. One of the settlements examined by the committee involved Innova, a payday lender whom the Bureau found illegally took $2.6 million from consumers' bank accounts without authorization. The settlement did not require Innova to return any of the money it illegally took from consumers. The committee's majority staff report revealed that your political appointee overruled the recommendations of career enforcement attorneys and nonpartisan senior management officials to require Innova to provide consumer redress. The political appointee rejected not only the recommendation of career attorneys, but also the opinion of the Consumer Bureau's legal division that returning the money illegally debited was appropriate. Why did you not require them?
Chairwoman, let me note that every case is fact and circumstance specific, and we have to apply the law to those facts.
No, just tell me about Innova. They took the, well, let me ask you, did they take the money from consumers' accounts without their knowledge? Did you find that was true?
That is certainly the case.
Okay, that is true. Okay, all right,
yes.
Thank you. Having done that, and having done your investigatory work, et cetera, you got to the point of a settlement, is that right?
Yes.
But you denied the victims any compensation. Why?
It is a negotiated settlement. It was the Bureau's estimation, my estimation, and the recommendation of the staff that we engage in this settlement discussion with Innova, and that was going to bring.
Okay, may I interrupt you for a moment and tell you that your career staff advised you that you should compensate the victims, and it was overruled by your political staff. Is that right? Is that true? Did your career staff advise you? Did your career staff advise you that they should be compensated?
Every case is...
No, just this case. Did they advise you?
I expect a robust
Did they advise you?
Ms.
Kraninger,
that brings everyone's input into
did your
this
career
process.
Staff advise you that these
decision.
victims should be compensated? Did they advise you that these victims should? Yes. Did your career staff advise you that they should be compensated?
The decision on the settlement was mine, and as we move
okay,
forward
so
with
let
case,
me conclude that you refused to answer the question, and you've decided just to answer it by saying that it was your decision, which means that you overruled your career staff and you took the advice of your political advisors. Is that right?
I took into account the full advice of the deliberative process, as I have in every other case.
As I understand it, Innova offered $1.6 million for the consumers. So they basically said, yeah, we did it. We were wrong. We should have compensated, but I guess we can offer them $1.6 million, and you said no. Is that correct? Why did you say no?
Chairwoman, again, there is a lot of back and forth.
No, I don't want to know about the back and forth. I just want to know, first of all, did Innova offer $1.6 million to the consumers? Is that correct?
Chairwoman, it was a negotiated settlement.
Did they offer $1.6 million to the consumers who had been harmed, and you turned it down? Just tell me, did they offer $1.6 million?
Chairwoman, you're probably referring to documents that I don't have in front of me.
Well, yes, you do. Listen, I beg to disagree with you. And don't try and come to this committee and not answer the questions and filibuster and pretend not to remember. This was a big case. They offered $1.6 million, and you turned it down. You turned down the advice of your career employees. You took the advice of your political appointees, and you knew exactly what was going on. You were aware of the committee's interest in these matters. We requested information about these settlements in February. And so what I guess I'd like to just end my questions with a statement by saying, for whatever reasons You have made these kinds of decisions. They're not in the best interest of consumers, and I'm very, very concerned about that. And I yield back my time to the gentleman from